Deputy Public Defender Oscar B. Rowe with a lesson on intoxication as a criminal defense. I refer to intoxication as being a defense, but actually intoxication is not a defense to a crime. When a person is intoxicated through drink or drugs and commits a crime, the level of intoxication may be such as to prevent the defendant from forming the necessary mens rea, criminal intent. The general rule on intoxication is that if a defendant is voluntarily intoxicated and commits a crime, this is not a defense to the actions. There are some exceptions to this, but as you'd imagine, public policy plays a strong factor in deciding whether the defendant's intoxication may be used by a defendant to negate the mens rea of a crime. It's not in the public interest for criminals to escape liability simply by saying that they were so drunk that they didn't know what they were doing. In fact, this is often seen as an aggravating factor rather than a mitigating factor, particularly where the defendant put themselves in that position in the first place. There are two ways that you can become intoxicated. Voluntary intoxication is where the person has chosen to get themselves drunk, whereas involuntary intoxication is where they haven't chosen to get drunk. For example, a person might have had a beverage spiked with a drug. The law views that differently, and involuntary intoxication could be a defense to a crime. The theory being is that they are not able to form the required mens rea for the crime, not through their own actions, but because someone caused them to be intoxicated. This is a simplified explanation of the intoxication defense for this class. If you choose law for a career, like I did, then you will explore this issue in more depth and detail.